He is a president of Hyderabad Insolvency Professional Association. He is a DISA qualified CA, insolvency professional and registered valuer of securities and financial assets. He's having a rich experience of around 16 years in forensic audit and internal audit. Then we have CA G. Kalpana, a secretary of Hyderabad Insolvency Professional Association. He is a chartered accountant by profession, registered valuer of securities and financial assets, having more than 17 years of experience in forensic audit. Then we have CA G. Kalpana, a secretary of Hyderabad Insolvency Professional Association. He is a chartered accountant by profession, registered valuer of securities and financial assets, having more than 17 years experience in taxation, audit, project finance. Then lastly, we have CA Sunit Shah, founder partner of SKYZ Company Chartered Accountant. He is a DISA qualified CA, insolvency professional, having experience of around 18 years in practice, and he is expertise in forensic audit. He is also part of the managing committee of Ahmedabad branch of WARC of ICAI. Now over to you, CA Sunit Shah, for opening remarks.
Thank you, Rishabh. I welcome you all to this again back to back. This might be the third session that we are having. First was on Rainbow Papers, Vidarbha Industries. Second was again on the amendments of CRP regulations by IBBI, and this time it's about all the liquidation. So now when we have seen the last session was about the CRP regulation, it's like if we are done with the CRP regulations, now welcome to the world of liquidation regulations amendment that has come up. So I think so Nipun sir and the panel that we are having, Suresh sir, Sanjeev Pandey sir and Hemanshu Kapadia sir, they will be taking it forward. Mostly there will be 4 amendments so far as I am aware, which will be much more affecting to the liquidators as well. One is about the section 230, that is the compromise and arrangement. There's a bigger change that is coming up probably. Second is about the liquidators fees. Few amendments are there in relation to the section 230 compromise and arrangement. Third is about the filing of claims by the claimants, which will be the further called a stakeholder committee. And fourth is about the filing of an progress report through a IA, rather than just we used to keep on filing the progress report by sending the signed document to the NCLT. Now I think so it's a bigger change that has come up, that every progress report will have to be filed in the form of an IA. So all these and much more will be covered by the experts here, Nipun sir and all the panelists here. Over to you, Rushan.
Now I would quickly introduce the panelists. We are privileged to have with us Shri Sanjeev Pandey, DGM, NCLT, SBI SAR Corporate Center, Mumbai. Mr. Pandey is a retired DGM of Stress Asset Resolution Group, SBI. Mr. Pandey started his career with State Bank of India as a probability officer during his 36 years of journey with SBI. He has worked on multiple assignments in commercial banking, project finance, etc. He has also exposure of carrying international banking as a head of treasury of SBI Singapore in the year 2009 to 2014. He has also participated in various group of personal insolvency, cross-border insolvency, and group insolvency. As a DGM of NCLT, his role included the drafting of banking policies, SOPs, and of CIRP, liquidation process, individual insolvency, and pre-pack insolvency. Mr. Pandey is a regular speaker on IBs related topics at various public forums and seminars organized by IBBI, IPA, ICSI, and various other IPEs. Mr. Pandey retired from SBI on 31st May 2022, and he has registered himself as an insolvency professional with IBBI. And Mr. Pandey is currently engaged with DSK legal solicitors and lawyers as an insolvency professional and restructuring consultant. Welcome, Pandey sir.
Thank you. Thank you.
Now we have Mr. CS Hemanshu Kapadia as a panelist. He's a practicing company secretary and a partner in Mehta and Mehta Insolvency and Restructuring LLP, and a member of Indian Council of Arbitration. He has experience of more than 2 decades in practice in the area of corporate law and his administration on issues relating to corporate governance, mergers, acquisition, buybacks, and private equity. Then we have welcome Hemanshu sir.
Thank you, Rishabh.
Then we have CA Mahalingam Suresh Kumar. He is a practicing chartered accountant, insolvency professional, and a registered valuer of securities and financial assets. Currently, he is a partner in SPP and Company Chartered Accountant. His area of specialization includes FEMA, transfer pricing, international taxation, IBC, and commercial arbitration. He is a regular speaker in various seminars and webinars organized by various institutes such as ICSI, ICAI, IBBI, etc. Welcome, Mahalingam sir. Next, we have Mr. Nipun Singhvi, an eminent speaker. He is a practicing advocate, qualified CA, CS, and forensic auditor. Recently, his research paper was selected by IIM Ahmedabad on sale of company as a going concern under liquidation. His frame was published in Anusandhan by IBBI. He was also awarded by Divya Bhaskar for excellent contribution in RERA. He has delivered more than 1,500 lectures on various laws across 50 cities. He has advised and handled 600 plus IBC cases, having debt more than 1 lakh crore. He is a financial activist, social activist, and RTI activist. So over to you, Nipun sir. Now, this time we have small change. We'll first of all discuss all the relevant amendments on liquidation. Thereafter, we have a panel discussion followed by question answers of the participants. Over to you, sir. Thank you.
Thank you, Rishabh. Thank you, Sunit ji. And a very good evening to all the participants and my esteemed colleagues and panelists. So today we are going to discuss the liquidation regulation, and I think it's a very big change because every day I am getting number of queries on how liquidation amendment will hit, how consultation committees has to be reworked, how consultation committees which are already there maybe for years into existence now will have to be restructured, revamped, and again you have to file it with NCLT. So this liquidation regulations amendment are very important for all of us, even otherwise. So I will go just sequence wise as Rishabh has told. I will just finish off the amendments and then we will have discussion together on the amendments. So the first important amendment which comes is with regard to compromise or arrangement. So as we know that there was an amendment whereby compromise and arrangement which was not there previously was introduced because of Gujarat NRE court judgment. And thereafter the matter went up and down till Supreme Court, and it was confirmed that a company can be sold as a going concern even under liquidation. Now the problem was that once the liquidation triggers, there has to be some resolution to sell the company as a going concern before the liquidation starts. Now the amendment which has come is whenever the application has been filed by the liquidator, by the RP who may be liquidator or may be replaced by some other RP as a liquidator. The point is that compromise or arrangement could only begin after the liquidation order was done. The amendment says that there is a new insertion of a regulation called 39BA in CIRP regulation. Now, at the time of taking the decision to take the company into liquidation, compromise or arrangement will also have to be resolved. And therefore, compromise or arrangement now will have to be specifically passed at the time when COC is deciding to take the CD into liquidation. The time period which is given for compromise or arrangement is 90 days. It is not changed. It is the same. But the amendment says that pending the application for liquidation, COC will keep on exploring the chances of compromise or arrangement, and therefore the liquidator shall file the proposal within 30 days of order of liquidation. So basically now a cap of 30 days has been put on the liquidator that if the COC had already decided to go for scheme of compromise and arrangement, the proposal have to be put before the NCLT within 30 days. So that's what this particular amendment talks about. It does not change the overall cap of 90 days, but it keeps a cap of 30 days. Previously, there was no such cap with regard to filing of proposal with NCLT. So this is an important change for compromise or arrangement. Second and most hitting change is with regard to the liquidator's fee. So there will be some controversies and some interpretation at this point of regulation 4. Here they have brought in a new regulation 1A. Previously, what was done was if there is a fixation of fees of liquidator, it is well and good. If not, then regulation 4 would apply. So that was how the regulation 4 was interpreted. Now they have introduced 1A, a new regulation, where they say if no fee has been fixed under sub-regulation 1, the consultation committee may fix the fee of the liquidator in its first meeting. So therefore, if something is not resolved at the time of liquidation, now they have given the power to consultation committee. So one thing which was not there previously is that consultation committee now has a power to decide what to pay to the liquidator. This was absent previously. So one thing is, if the liquidation is starting, liquidation order has passed, liquidation is commenced, the first thing in the first meeting has to be done is fixation of the fee of the liquidator. Then sub-regulation 1A has been inserted in regulation 4.2, which says that suppose there is an already there is an approved fee, what should be done? So here I think there would be some interpretation. I will just club this when we come on to 31A. But as of now, fixation of fee has to be done in the first meeting. What will happen in the subsequent meeting? I would come on to it in 31A. Second big change, and I think it is something related to rainbow papers also, or it is a effect of rainbow paper. Here they say that in case of public announcement by liquidator, wherein already there are regulation 12, there is already A, B. Now they have introduced the C, which provide that where a stakeholder does not submit such claim during liquidation. Now we have seen many times during CIRP, somebody must have submitted the claim, and in liquidation, they do not submit. Or there could be a situation when somebody has not submitted in CIRP and they come first time before the liquidator to submit a claim. Now here what they have tried to do is they have tried to protect the persons who have already submitted the claims during CIRP. So here the wordings used are, if the stakeholder does not submit his claim during liquidation process, the claim submitted by that stakeholder duly collated by IRP or RP during CIRP shall be deemed to be submitted under section 38. So basically under liquidation, everybody is required to submit a claim. But now they have put a deeming provision, assuming somebody has not submitted, then whatever was submitted during CIRP process, that shall be deemed to be submitted in liquidation process. Second amendment, though it's a procedural amendment, but quite interesting, that process email ID, this has been brought in CIRP as well as liquidation. We have already discussed it in CIRP. Same thing is there in liquidation. Whoever is incoming and whoever is outgoing, everything in the email ID will have to be handed over. So now basically the rights and controls will have to go with the email ID also. This is an important amendment wherein previously the regulation said that progress report would be filed with the adjudicating authority. Normally this was done, but now they are saying that liquidator is to compulsory submit progress report in the format given by IBBI. So till date, they have not given any format, but probably IBBI will come out with the format. Here they say not only to the NCLT, to the IBBI also. So we were submitting progress report normally in the form of a PDF to IBBI as well as to NCLT. Now the directions of the president are anything you want to submit with the NCLT without an IA, you cannot submit it. So first thing is with the NCLT, you have to file an IA to put on record whether it is progress report or status report. So whoever are doing liquidation, all the participants, if you are moving a status report or a progress report, now NCLT registry will not accept it without an IA. Secondly, as soon as the format is being given by IBBI, you will have to file it in the format given by IBBI. So this is the amendment. Now, previously what was done was, there was a proviso which said that the progress report should have a statement wherein they would say what is the expected realization of the property. This particular progress report or asset memorandum was not required to be divulged to other stakeholders, or it could be only divulged with the approval of NCLT. So it was till date considered to be a confidential document. Now here the confidentiality goes away. The amendment removes the proviso, and therefore now all stakeholders have an access to progress report, including the statement wherein the realization of the property is also disclosed. So now every stakeholder will have an access. So it is more towards transparency. Now the amendment which we talked about 3-4 slides back regarding the claim. So deeming provision that claims would be considered whatever has come in CIRP. Now regulation 30 says that the liquidator shall, so here it is mandatory, liquidator shall verify the claim submitted. So firstly, it was within 30 days from the last date of receipt of the claim, I would have to verify. But now the proviso says we have to verify all the claims collating during CIRP, not submitted during liquidation process, within 30 days from the last date for receipt of claims. So here the deemed claims as per the regulation which we read just 3 slides back, here we have a 30 days time period to admit or reject the claim. Now, most of the participants would be thinking that if some claim has been admitted or collated and verified by IRP, does the liquidator have a power to change the decision? Yes, this regulation 30 gives us that power, and we will have to either increase it, decrease it, or make it as it is. It depends on the proof submitted with the claim, and whatever is the admission or rejection of the claim, that can definitely be appealed before NCLT under section 42. So that section 42 appeal is there, and as per the liquidation regulation, a liquidator is an adjudicator, RP is not an adjudicator. So therefore RP powers were limited, but under liquidation, liquidator has wide power. And the most important amendment comes in regulation 31A. It is the stakeholder consultation committee. And I would like that all of you give full attention to this regulation, because this is something which will come in day-to-day affairs. So let us read what was previously there. So the previous regulation 31A was the liquidator shall constitute a consultation committee within 60 days from the liquidation commencement date. So within 60 days, we had to make SCC. Now read the new law. The liquidator shall constitute a consultation committee comprising of all creditors. Now here the words used are all creditors. Now this is very, very painful, because there could be lakhs and crores of creditors in a company. So this is something which is very much important. They have used the word all creditors of the corporate debtor. As I move forward, I would clarify how it has to be interpreted. But as of now, the words used are all creditors. Then they say within 60 days from the liquidation commencement date. So 60 days time period is the same. So within 60 days of LCD, you have to call for SCC. Now, what was previously required to go through SCC? So there were only 2 agendas which we used to take it to SCC. One was appointment of professionals and their remuneration during liquidation, and one was sale under regulation 32, how to make the sale, what would be the pre-bid qualification, reserve price, EMD, marketing strategy and all. So basically how the auction process will go on. Only these 2 things were required to go through the SCC. And there was a proviso that the decision taken by liquidator prior to constitution of consultation committee shall be placed before consultation committee in first meeting. So it was more like an informing the committee rather than taking permission of the committee. But you see, now the process has completely changed. Now they have brought around 5 agendas. So first, second is same, but the third is very tricky. They have used the word fees of the liquidator. So now you have to bring to the notice of SCC about the fees of the liquidator. Second is bring them to the notice what is the valuation. And third is the preferential, fraudulent, undervalued, extortionate application, who will run it and who will get the benefit. So these are the 3 amendments. Now, first is fee of the liquidator. So first question will come, if my fee is already fixed, can the committee reduce my fee? So again, this is a matter of debate. If we plainly read it, answer is yes, fees of the liquidator can now be discussed with the consultation committee, and consultation committee can vote on it. So in the coming regulation, I will tell whoever are the members of the SCC, they have a right to vote also. Second issue, I will take all these issues with regard to voting also again. Valuation. Suppose the SCC says the valuation is not appropriate, they can ask the liquidator to get the valuation done again. They can ask the liquidator to go for third valuation. And last one, the puff transactions. We have seen that liquidation normally ends in closure or dissolution. So closure in case it is sold as a going concern, dissolution in case we are closing down the company. Now the last clause says that who would run the show. So suppose they want to authorize liquidator to run the puff transaction application. So they will have to put aside some money. So they have asked mandatorily clarify who would run the show. And secondly, whatever amount is coming, how to distribute that. Now, my personal view is that distribution, what they have said in clause E, is tricky because distribution, according to me, would always be as per section 53. 53 section cannot be jumped because of a regulation, because regulation are always subordinate to the act. So basically, E is a clarificatory in nature. But yes, this was a difficulty which many liquidators were facing, that puff transaction application, SCC was not taking a call. Now it is the duty of the SCC to take a call on the puff transaction application. So another important amendment is, normally what was happening, suppose COC took a call of liquidation and the application is filed. Sometimes 6 months, sometimes 1 year, sometimes I have seen 2 years also pass and liquidation order is not made. So there was a confusion and some benches were of the view that COC is ex officio, though that was verified by the withdrawal judgment. So there was a ambiguity that whether a COC can take place when the liquidation application is pending with the NCLT. Now they have clarified that the COC can take place. They have amended in CIRP regulation. And the second amendment what they have brought is that till the SCC is constituted, so that is 60 days, who would function as SCC? COC would function as SCC. So basically consultation committee powers would continue with the COC until SCC is formed. This is very important for all the matters in which liquidation is being done now. Now, what they have done is, previously there was a table like this where we used to have financial creditor. Now there were cap of 2 and 4 depending on the claims. Unsecured financial creditors also there was a cap. Workmen, employees, government, operational creditors, shareholders. There was a cap on every category. How many people could maximum come in the committee? But now they have removed the cap. So this is very, very interesting. And this is going to be a very big challenge for all of us. First is, there were categories, that categories have been taken away. The table has been deleted. Now the law says voting of member of consultation committee shall be in proportion to his admitted claim in the total admitted claim. So first is, whoever is in the consultation committee would vote in proportion to the claim he has to the total claim. So everybody in the committee first of all has the voting rights. That is clear from sub-regulation 2. Now they further qualify. In the first proviso they say, if some financial creditor has already taken under section 52. So if there is a secured creditor, some bank is there and they are going and selling their asset under 52, they will go away. They will not form part of the SCC. So this was very clear. Even previously they were not allowed in the SCC if they have taken away the asset. Second is, promoter, director or partners may attend but will have no right to vote. Again, the same concept we had in COC, related party will have no right to vote. Third is, a financial creditor or his representative, if he is a related party, he would not be able to vote. So 2 points. Promoters can't vote. Related party who is an FC can't vote. Same thing which was there in COC. Interestingly, the third amendment is very tricky wherein the table which was deleted is now coming by way of a theory. Here they say liquidator may, so there is a choice with the liquidator, may facilitates the stakeholders of each class, namely financial creditor in a class. So what he will facilitate class of financial creditor, he will facilitate class of workmen, employees, government department, other operational creditors, shareholder partners to nominate their representative for participation in the consultation committee. Now, this is the biggest change. The smaller the regulation is, the bigger impact it has, because they have removed the complete table which was giving them an upper cap. Now, see what would happen if there is a government departments. What all could be there? Income tax could be there, GST could be there, sales tax could be there, ESI could be there, PF could be there. All these departments, to choose one person definitely is going to be controversial. And the language uses may facilitate the stakeholders of each class. So he will have to pick and choose from the particular class who will represent. So I am telling you, on a safer side, I have been suggesting everybody go by whatever departments are there, ask them to nominate their person, because that is the safest way. Because in government departments, as we know, impact of rainbow is still, we are still understanding how rainbow would impact. So on a safer side, ask all the government departments having huge claim to nominate somebody. If they do not nominate, that's a different issue, but we will have to ask them. As far as operational creditors are concerned, my suggestion is that you take somebody who is having the highest claim in the class of operational creditor. So that will suffice. The total class of operational creditor, whoever is the highest claimant in that class, you can take that person. Now, if you ask me whether this is possible, I think there is a drafting issue. There is a drafting error. There will be definitely a clarification from IBBI, because the discussion paper which was floated before this liquidation regulation, the language used was the stakeholders which are going to get payment under section 53, they should now come in the SCC. So the logic was somebody who is going to get payment as per the liquidation value calculated by the liquidator, that payment whoever is entitled to receive should be forming part of SCC. But the regulation is silent on that aspect. So therefore, my suggestion to you all is you can ask somebody from every class, but as far as government department is concerned, as far as financial creditors are concerned, call all of them. Because in financial credit, I have seen, let's say there are 5 FCs, you are calling only 2 or 4 as the case may be as per the earlier table. Now you have to call every one of them. It is better to call everyone rather than fighting with them that you don't have a right. So this is my view with regard to regulation 3. Then regulation 4A, it's a clarificatory regulation which says that everybody will have a right to vote as far as the amount is concerned. So total amount and their amount outstanding would be the voting share. So that's normally we do the same thing in the COC. So I think that will not be a bigger trouble. The another amendment is in regulation number 6. Now the regulation 6 says that the liquidator shall convene a meeting of consultation committee when he considers necessary, and shall convene a meeting when there is a request of 51% of the representative. So if 51% comes together, he will call it. Now that 51 is changed to 33%. So 1/3. Basically now they have reduced the amount where request can be received from SCC to call a meeting. Second change is the liquidator shall convene the first meeting of the consultation committee within 7 days of the liquidation commencement date, and may convene other meeting if he considers necessary on a request received from one or more members of the consultation committee. So now what they are saying is first consultation committee should be in 7 days from LCD. So first meeting within 7 days of LCD, this is what the regulation is now saying. When we started, we said that within 60 days, he has to convene a meeting, and in that 60 days, COC would continue to represent whatever is going to come in the consultation committee, they would be subsequent to the COC. So now liquidation would happen, then COC would continue, then it would be reconstituted as SCC, some more stakeholders would come in. So this will be in the future matters where we are getting liquidation order. Now, what about those matters in which already we have been doing liquidation? So I think I will first come on to that. So first I will tell what will happen to existing matters. So existing matter, the proviso says that the consultation committee has to be constituted within 30 days. So reconstitution of the existing consultation committee in accordance with this new amendment should be in 30 days. Now you all would be wondering, what is that 30 days? 16th September, this was amended. So 30 days ends on 16th October. And we are today on 13th October. So suppose you have not taken into consideration these amendments, immediately call for a reconstituted SCC. You have only 3 days more to reconstitute them, and definitely you will have to follow all the procedure of after reconstitution. Now I am going back to the regulation amendment. So another amendment is that previously it was consultation committee shall advise the liquidator by 66%. So it continues to be 66%, but the words used were present and voting. Now the word is only voting. Present and voting has been replaced by only voting. So voting is important, and voting should be 66% in case of any advice given to the liquidator. And if the liquidator does not go by the advice of SCC, then he will have to explain why he is not going with the advice of the SCC. Now here there is a very big change. What they say is, if you are not going by the advice or by the consent of the SCC, within 5 days, you will have to submit the record relating to that decision to NCLT and IBBI. Now, let me tell you, friends, as far as NCLT is concerned, there is no form to be filed. So you will definitely have to file it by way of an IA, that this is the reason why I am taking a different stand than the decision given by the SCC. Secondly, they have also said you have to intimate to the board within 5 days of the decision. So this is very important that you have to intimate it to the board, intimate it to the NCLT, thereby casting an additional, I would say, compliance on the liquidator. And it is, I think, a reason why some of the liquidators were not doing SCC or were not going by the decision of SCC. This amendment has been brought to bring about more transparency, and automatically it is going by the check of the regulator. Because if within 5 days you have to inform to the regulator, and suppose regulator wants to take some action or wants to tell liquidator that you have to go by the decision of SCC, probably that would happen now. So this is an important amendment, and I request all of you to take an important note of it. We will deliberate in the panel, but this is an important amendment. So the next amendment is with regard to sale as a going concern. So previously it said that if the liquidator is unable to sell the corporate debtor as a going concern or going concern business of the corporate debtor within 90 days from the liquidation commencement, then he would proceed like selling of assets in parcel, individual assets, all those bunches of assets could be sold. Now they have amended it and they say that liquidator may sell the assets of the corporate debtor under clause 32E exclusively only at the first auction. So the amendment means that if sale of a corporate debtor as a going concern has to be done, it has to be done exclusively at the first auction. So the first auction technically will be sale of a corporate debtor as a going concern. This is what this particular regulation says. Second is conduct of the meetings of consultation committee. Previously, there was no law as such how to convene a meeting, what should be quorum, what should be minutes, how it should be circulated. Now they say whatever you do in COC, all the provision applies mutatis mutandis to the provisions of conducting meeting in SCC. So everything right from agenda, notice, explanatory statement and minutes like draft minutes and final minutes, the complete procedure would be the same. this would be applicable because of this regulation 32B. Second amendment is with regard to the asset memorandum. So the amendment says that with the liquidator within 30 days from LCD present an asset memorandum in accordance with this regulation based on the IM prepared under section 29 with suitable modification. So what they've tried to do is whatever has been done by the RP or IRP and the information memorandum which was prepared by them would be used as a basis for asset memorandum in liquidation. So this is very important now. Whenever we take handover from the erstwhile RP, we will have to be sure whatever he is handing over and it is matching with the information memorandum which was there, which was made by him. Second is when valuation is done during liquidation. So for cases of 35(2), the liquidator shall prepare an asset memorandum in accordance with regulation within 75 days from liquidation commencement date. So I would only say that now the asset memorandum is important. And if there is any lapse between information memorandum and asset memorandum, I request you all immediately approach NCLT. I have seen this live in one case wherein what had happened was in information memorandum, some assets were disclosed. But those assets, when the liquidator was appointed, a new IP was appointed as a liquidator, he was not able to identify them. So probably this is something which is important, that whatever was there in information memorandum should now be there in asset memorandum also. Previously, asset memorandum was confidential. Now asset memorandum is not confidential. Now the liquidator shall, so it's compulsory to share the asset memorandum with the board, that means IBBI, and the member of consultation committee. The same way we used to share the valuation report, take a confidentiality undertaking, same is the logic of this amendment. Now, completion of liquidation, as we all know, regulation 44 said that how do we complete the time period of liquidation. Previously, it was 2 years, then it was reduced to 1 year. Now they are saying that whatever is there in the liquidation period we are doing, what should happen to avoidance transaction application? Some NCLT benches were of the view that you cannot close the liquidation because the puff transaction or the avoidance transaction application is pending. So now they have clearly said that notwithstanding pendency of any avoidance transaction application before NCLT, so the liquidator shall liquidate the corporate debtor within 1 year. So that is sacrosanct. And now that puff transaction, even if it is pending, you can close it. So company could be liquidated and closed even when the puff transaction applications are pending. However, they have clarified that those puff transactions, two things have to be resolved. One is who would continue these applications. So who will pursue these applications after dissolution or closure? Second is the manner in which the proceeds would be distributed. So again, I think manner in distribution, they cannot do much here because SCC cannot override section 53. The distribution would be as per 53 only, but they have to now clearly say who would pursue and what would be the cost. So now we will have to pass a resolution at the time of closure or dissolution saying that this much is the amount of litigation for puff transaction. So therefore now an additional prayer will have to be made in the application of dissolution or closure as the case may be. So the last amendment is with regard to keeping of the records. So they are just prescribing that you should preserve the copies of the records. And I don't think much has to be discussed on this preservation of records. It's more of a procedural nature. So I think, Rishabh, we can now start the panel discussion because I have taken all the amendments.
Yes. What you, Mahalingam sir?
I think how we can have it, Nipunji, one by one, class by class, we can get into it.
So I think we can discuss on the SCC, the constitution of SCC, because I think that would be much more important for the participants.
Yeah, the most crucial thing for all of us, where everybody has a huge work to carry out in the first 30 days of time. The biggest challenge as liquidator we all face is within 30 days we have to reconstitute one. That is a bigger task, especially at the quarter end where you have to submit 15 days the progress report also parallelly. Second, the biggest challenge here is when the committee is already represented with existing some representations. Whether we can continue to have the same representation and we can ask the people's negative way of taking out the existing, it is represented with the current so and so people. Will you continue with them or would you like to change? That's the scenario one side. The problem here, challenge for us is when it comes to employee or operational creditor, in case if 20 OC, 40 employees, if they all of them say that I will represent, so now the challenge comes to the liquidator, whether we have to take all of them or in the regulation, the subsequent to the 3, 4, when you see it up, if they fail to nominate, there is an option to chase the highest valuing creditor. So now if 40 employees offer themselves to come for the meeting, conducting the meeting with the 40 employees and taking their view, if we don't listen to them, then they will make an objection in the whole thing. So hearing everybody will be a bigger mess. So what is the suggestion you give, Nipunji, in that matter?
Sir, my suggestion is that in case of worker and employees, we can get one representative. And as far as the claims are concerned, if we take the highest amount of exposure, we should nominate him and we should inform others that we have nominated him. If somebody wants to object, then we would say that you can go to NCLT. Because worker and employees, normally, if you see in COC also, there is a representative concept only. I only think the problem will come in the case of operational creditors, because there is no guidance in the law with regard to operational creditors. And also I have got one query with regard to one of the companies which was listed. So there are some crores of shareholders. So here they have also used the word shareholders. So I really feel very difficult how to work out on the shareholders, because technically speaking, crores of shareholders and everyday shareholding would be changing. So it will be very difficult to take the closure date, find out who has the highest number of shares, and then ask for being nominated for that class. So I think that would be a challenge. But I think that as far as worker employees is concerned, we can take nomination.
Yes, I understand. But here the technical issue, what people have come across is that, see, every employee has a voting share, 0.001 or some percentage is having a voting share. So he says that I will attend, I will come. If 40 employees say, now liquidator cannot tell that, no, you all are represented by so and so. When the employee gives a written letter to us that he will represent. So because he is having a meager voting share of some fractional percentage, we are bound, means we cannot reject it all. That's a tricky problem before us. So if we reject, will it not become a non-compliance or a contravention by the liquidator? And it will...
You are absolutely right, sir. Pandey sir, your views on this, sir?
Yeah, my view is that since there are already guidelines for authorized representation in COC, so I think we should follow same here also, because now SEC is going the COC way. Most of the guidelines for SEC are similar to COC. As you said, in particular section, all the COC guidelines will be followed by SEC, the minutes, everything. So why not follow the authorized representative guidelines also, where we tell the particular class of OCs, you bring the authorized representative and he will attend. Ultimately, the basis structure of SEC or COC is that it cannot be a public meeting. It is a confidential forum where everything cannot be discussed in public. There are many documents, many discussions, it is totally confidential. So I think we have to follow that, or maybe seek a clarification from IBBI. But right away, we should go with that authorized representative guidelines for every class of SEC members.
Hemanshu ji, your views, anything else to add?
Sir, I fully agree with what my other panelist says, but one of the questions which definitely arises that the liquidator do not have any discretionary power, or okay, that whoever come forward and he will agree for that, because there is always going to be conflict between the 2 or 3 operational creditors, and everybody would like to come on the committee because they have a right to represent. So how to restrict the representation is a big challenge. So constitution of the committee is going to be a challenge, and it will be, I think, evolved over a period of time. So some guidance or suggestion from the IBBI will be very helpful. Say, for example, you said that, okay, we will initially consider the highest amount of the operational creditor as our representative. But the second one says that, no, you don't have power. I will definitely come forward. I'm also equal stakeholder. So how to restrict? Some guide note on that aspect may be very helpful to decide this issue. Otherwise, we again end up into litigation, and every single application to the regulator will delay the process rather than expedite.
I actually forgot one of the regulation. I think I skipped it with regard to the replacement of the liquidator. So now they have brought in this that SCC with voting of 66% can replace the liquidator. I just display it on the screen. So the consultation committee, after recording the reasons, may by majority vote of not less than 66% can replace, and the new liquidator consent can be obtained. And for whatever work has been done by the erstwhile liquidator, he will be paid appropriately. That is what this particular amendment says. Now, I think this opens a Pandora's box, because now the liquidator who has worked, because normally what happens is the liquidator works, he will sell the assets, get the money, and then distribute that particular amount. Now, if suppose, assuming I have sold the assets, got the money, but I cannot distribute it because of any XYZ stay of maybe NCLT, maybe Supreme Court. Now, in that particular case, if another liquidator comes in and replaces me, would I be paid for the realized amount which is not being distributed, or I would only be paid some money and told to go out from the process? So I think, sir,
my view is that there are 2 payments to the liquidator. One is for realization and one is for distribution. All right. So here the liquidator will lose the distribution part of his fees. Only the realization part is.
Even in the realization part also, the first liquidator will take only half of it. The balance of the realization portion will be eligible for the distribution leg only. So it will shift to the liquidator. See, ideally, this issue will become, but depending upon the cases, I presume that the liquidator, whoever is outgoing, he may get the monthly remuneration basis, maybe at par with whatever CIRP, RP got it. See, instead of getting into this percentage, RP might have worked for some fixed fee for some X months. So the same slab may come here. See, that is what the slab applied if you are selling the unit under 230. If you are transferring it. So looking into the past things, there is a scenario that the liquidator may get the similar things what RP would have got for the outgoing liquidator. So the precedence of the law looks like that.
I think there is a nuance in the RP fees also. Recently, they have mentioned in the minimum fees that after the resolution plan or liquidation is filed with the NCLT, the fees of the liquidator or the resolution professional will be decided by the COC in the last meeting. I think that fees can continue till some distance.
No, recently I have quoted, I'm Ramesh here, liquidator from Hyderabad. Hello.
Yes, sir. Yes, sir. You are open. Tell me.
Recently I have quoted State Bank of India or some other people wanted me to apply as a liquidator. And they said, please quote your, they said, please go by schedule only. We will not give you monthly fees. So then I said, in case you want to remove me at any point of time, till the date of removal, from the date of my appointment, please give me a fees monthly, fixed, say 3.5 lakhs, because normally as RP, depending on the size, we charge 3.5, 4 lakhs. That's the agreement between us and the COC or the SCC for that matter. So I have clearly mentioned in my quote with the bankers, saying that in case you want to remove me before the liquidation process, from the date of liquidation commencement date till the removal date, please give me at the rate of so and so 3.5 lakhs per month or whatever it is. So that type of stand, if we take, SCC also will be very considerate about removing us just like that. Or at the same time, you can reject the SCC proposal of removing us by going to NCLT. That's the next step. But coming to fees compensation with appropriateness, I think it is better that all our members write in their quotation right from the first day that in case you want to remove us, this is my fee. If it is okay, I think all of us can debate on
No,
this.
I think there is a better solution here. So I have suggested in some of the matters in a state bank, like we agree to a monthly fees for liquidator, at the same time with a condition that this fees will be adjusted in the final distribution or whatever the fees is coming as per a percentage of the recovery and distribution. So it is settled against that. I think same kind of model can be adopted. That you decide on a percentage fees basis on recovery and distribution, and then take a monthly fees, and that will be settled. So in between, if the liquidator is also changed, ultimately you get your fees, and that fees will be adjusted in the final distribution or recovery fee given to the other liquidator.
Actually,
Now,
only
I think one problem which would come, and which I think some of the matters have come, is previously the SCC we were normally calling only 2211. The committee was very limited and the voting rights were also limited. Now the voting rights and the number have spread. So there is going to be some problem, and I have seen from last 1 month, every SCC which is reconstituted is negotiating and renegotiating only on the liquidator's fee, except everything
biggest
is
risk.
renegotiating on the fee.
Yeah,
But
the
on the
biggest risk.
on the positive side, all these members will be sharing the fees also. Earlier, only the I think financial planners were sharing the fees. So now all SCC members, whoever comes in with a bigger vote, they'll also share the fees.
So Pandey sir has brought in a new angle that others will also pay the fee. But sir, I think that when we talk about 53, no, sometimes shareholders and operational creditors get nothing if we go by the distribution. So then they
So then they should be discouraged to vote or come in the SCC. You should tell them, if you vote, come and sit in SCC, you'll have to pay the fees. Whether you get anything or not, fees will be shared. So then automatically they'll get discouraged and they'll avoid sitting in SCC.
Now, sir, the controversy here is, if you go by the COC logic, they say that if somebody is in the COC, even if he does not attend, he has to contribute the cost. So that logic would somewhere clash. Some clarity is required on who would contribute and how it will continue. Though they have brought some clarity in 39A, B, C of the CIRP regulations, they have said that at the time of liquidation only, proposing liquidation resolution, they will say who would bear the cost and in what proportion. But the problem now with newly constituted SCC is the power to decide the fee has gone to number of persons, but the decision to contribute to the cost was limited to only financial creditors. So I think there is some dichotomy in both these provisions.
So, Nipun sir, I feel that now the RP has to take the consultation of the lawyer like you at the time of his appointment itself, that what would be the fees and remuneration structure at the time of RP, and if he continues in future as a liquidator, how his fees would be decided. Everything to be decided well in advance, so that this kind of situation can be avoided.
Sir, I have a query, sir. Sir, when you are talking about that, there is now a provision of a replacement of a liquidator, right? After the liquidator has been appointed. So will it be deemed that even liquidator will have an option to resign from his assignment? Because what we used to do initially is we used to fix our fees during the last COC meeting of the CIRP. At that time, even our fees was negotiated, and we used to finalize the fees with the bankers that as per the regulation 4 we'll be quoting the fees or the percentage lesser than that, or monthly fees we used to fix it. Now when they have postponed this, they appoint the liquidator and they postpone the fees structure to the SCC meeting. So we are being appointed as a liquidator. What happens if sir SCC is not proposing a fees which is acceptable to the liquidator after the liquidation order has been passed, and I have already worked for the liquidation, say for a month or 2 months before forming the SCC. In that case, sir, there will be an issue that I don't want to accept the fees which is lower than or lesser than what I expect.
So may I take this, sir?
Yeah,
So I
yes, Nipun.
I think, sir, in such a case, in fact, 2 of such cases I have fought in the court. Court is normally taking the guidance from regulation 4. So suppose the SCC has not fixed, or let's say it is silent. So law says you go by regulation 4. So we can go by regulation 4 and ask for fee. Now, assuming that regulation 4, any liquidation asset is not sold or not realized, as the case may be, then we will go by what we are getting in CIRP. So that is some, I am not remembering the judgment, but there is a NCLT principal bench judgment on this, that you can take the guidance from CIRP fee in case everything is silent during liquidation.
No, sir, not about silence. Means SCC is fixing my fees after 2 months of liquidation. SCC is, but
Yes.
they are fixing the fees which I am not expecting. Means say I am saying that my fees will be as per regulation 4, which is I am proposing, or it will be 80% of the fees which is proposed by regulation 4. That is my maximum cap. That is my having the lower cap. Below it, I won't go. But why? Because, and that happened because during CRP last COC we used to fix whether I want to be appointed as a liquidator or not. I used to decide at that very moment because the fees was decided that very moment. Now they are appointing me as a liquidator and now postponing the fees part to the SCC. So now SCC says, okay, no, you will be getting only say 10,000 rupees per month at that time. So what I will be doing at that stage, I will say, no, I don't want to accept this assignment even after 2 months have elapsed and SCC has been formed. SCC is agreeing to the fees, but they are agreeing to the fees which is much lower than my or the liquidator's expectation. What will be liquidator's stand at that time?
But sir, I think they cannot postpone it because now the regulation 39B of CIRP clearly says that they will have to decide on the liquidation cost, including your fee.
Yes, sir, but that will be decided after the liquidation order has been passed.
No. Regulation 39A, B, C, and now newly introduced BA. All these 4 regulations have to be mandatory in the COC in which they are proposing liquidation.
Okay, during CIRP process.
Yes. These regulations are of CIRP only.
Correct.
No, but Nipunji, here I think one of the section as you shown in your presentation, it
yes,
says
sir,
that
there was
SCC
one
can decide.
Yeah.
SCC can decide on the fees. So whatever was decided by COC, the new SCC goes for a lower fees. That's what I think.
Correct. But that is
point I just
with
wanted
regard
to
to
add. I just wanted to add one thing. See, actually, SCC has a power to intervene and fix a fee if the fee is not already fixed in the COC.
Correct.
If the fee is already fixed, they can see, if you see the particular that regulation wording, still the SCC will advise for fees fixation. See, as such, it was not mentioned as an absolute power of SCC to fix the fees. Again, that particular regulation was. So if the fees is not earlier fixed, now they can fix it. There is no mention that negotiate, refix the fees and all those things. If one's already fixed, they cannot change the fees without the concurrence of the liquidator, because it's a kind of a contract which you have already agreed with them.
But sir, one of the slide you said that there might be the case where SCC will fix the fees. So now it's not compulsory to fix the fees during the last COC meeting. That is the amendment, I think so.
No. Sunit ji, what has happened is in previous cases when there was no regulation 39B, there was no specific resolution for liquidator's fee. So in case everything was silent, we were going by regulation 4. That is what regulation 4 table says. Now in those cases, this amendment clarifies that SCC can fix the fee. So in case fee is not fixed, only then SCC would fix the fee.
Yes. Yes.
So first situation is those cases where fees was never fixed. We were going by presumption of regulation 4. That is now clarified by the amendment. Second is in new cases, 39B is mandatory. Liquidator fee has to be fixed before liquidation. Third is suppose liquidator fee is decided. Now they want to renegotiate. That can be done. So that is now permitted. So renegotiation is permitted because now what their logic is, let's say in COC there were 5 people and in SCC there are 15 people. So there is bound to be negotiation, and negotiation has already started, I am telling you. Now the part for which you have already worked, they have clarified that you will be paid appropriately. So that is also there. So suppose you are not agreeing with the fee, you will be paid appropriately. I am just again showing the regulation 11. You see the proviso, it says where a liquidator is proposed to be replaced, he shall continue to the work till his replacement and he suitably be remunerated for work performed till his replacement. So they have clarified basically.
Can I pitch in here?
So sir, even liquidator will have a right to not to accept the assignment further. So that might also be the case.
No, can I pitch in here? 1 minute. See, this SEC is only not binding on the liquidator. So if 66% that they vote for a lower fees, within 5 days you can go to NCLT.
No, sir, I am again repeating the amendment. Amendment says that he will take consultation of the SCC, and SCC's consultation decision is different than his opinion. He will within 5 days go before NCLT and IBBI submitting why his decision is different. But whenever there is an issue of liquidator replacement or liquidator fee, 101% you have to file an application with NCLT. You cannot you cannot actually not go to NCLT and say I will take this much fee only, I don't agree. That cannot be a way of liquidator. He will have to definitely go to court and say, see, this is the fee they are offering me and I can't work at such lower fee. Therefore, please appoint somebody else.
No, see, Nipunji, I have a difference of opinion here. See, compulsorily going to adjudicating authority is only for change of liquidator. So now, if you see regulation 31A sub-regulation 1, the SEC to advise him on matter relating to fees of the liquidator. Fees, if you have already discussed and agreed in the COC, now SEC cannot refix the fee unless liquidator agrees for it. Now, fees is high, fees has to be reduced. That cannot be a ground. You cannot go to court to replace the liquidator because that is the agreement. You mutually agreed with the liquidator and you appointed him in the first sense. Now, that is not a valid reason for changing the liquidator. Again, fees is a matter. They are only advising. They don't have an authoritative right unless the fees is not earlier fixed and now they are fixing it.
Sir, let us read it again. According to me, sir, they are saying consultation committee after recording the reasons may by a majority vote propose to replace. So sir, consultation committee after recording the reason, sir, reason could be that I have a
only for replacement you will go to adjudicating authority, not for fees matters.
No, sir, I can always have a reason that I have a better and a cheaper liquidator and therefore I would go for a more economical liquidator. Who stops me?
See, that more economical than government department doesn't require a table. Na? They can leave it open to the market to do it for 1,000 rupees also. Na? Why should they have a table to have fairness?
Sir, I have in last almost 10 days, 3 COCs or now SCC renegotiating the fee and the liquidator coming from 3 lakh per month to 50,000 and 1 lakh per month. That is what has happened. And they have gone to NCLT. Obviously, that this is a revised fee. If he is agreeable, okay. Otherwise, we will replace him. So one case they have already replaced. File application for replacement order is yet to come. It's in NCLT Mumbai. I would share you when the order comes. But I think that
You
whatever
should defend-
reasons.
You should defend the fellow liquidator for change of the fees cannot be a valid reason for change of the liquidator if it is already agreed earlier. What is this? They cannot, people cannot keep on breaking the agreement, means contract between the liquidator and the SEC earlier one side, just because you are getting a cheaper alternative.
There was an order of NCLT Hyderabad in the matter of VNR Infra, which went to NCLT and then to Supreme Court. They changed the liquidator and they said that yes, liquidator can be changed, and it whatever was agreed, even the COC, and in fact, maybe Pandey sir may be knowing about it because SBI was also there. What had happened was COC agreed for one liquidator, but the other they did not agree with the same liquidator. They changed the liquidator. So even after when court said if you want to appoint somebody else, even if you have agreed, bank said okay, no problem, you can appoint. So basically change of liquidator can be because of XYZ reasons. And fee part, see, it's very difficult to comment on fee part because if you see the orders now, IBBI orders and recent orders, I will not name the orders, but you are aware, they are saying that higher fees charge and therefore it's not reasonable. So tomorrow you cannot say that fee is not a ground. Fee is a ground because IBBI themselves are saying.
Yeah, you understand. See, for example, most of the liquidation, the liquidator would have agreed Regulation 4 of Regulation 2 table. So, which government has already specified the table. On that table, you cannot come and tell this is high. This is government specified. This is in the regulation. So, here there is no question of fairness. Now you cannot come and tell that this fee is too high. What is this? Government fixes the fee and judiciary decides that this is high. That cannot be a logic, no? Then again, see, if this is permitted, what will happen is for the CARP already 1 lakh, 2 lakh, 3 lakh slab is fixed. Again, there also the COC will come and say, why should I pay 1 lakh? There is another person available for 50,000. This fixation is also not mandatory. It is again recommendatory nature because there is a cheaper cost. CARP will done. Such kind of argument will only distort and quality will deteriorate only if they do it. Obviously, I expect that courts will play a fair role in ensuring that there is a quality is maintained in that respect. Let's see, you also have to defend in the Mumbai case to fellow liquidator strongly.
No, what I have suggested the RP that till that liquidator, that until the new liquidator comes in, you continue whatever you are charging for whatever work you have done till now. Don't reduce it, because if you reduce now, the court might take a view that because you have reduced, therefore you should work at this reduced fee.
Absolutely. And in fact, Nipun sir, I am of the opinion that all the professionals, those who are, as a chartered accountant, company secretary, we are well aware that underquoting the fees in any assignment is it is prohibited. You can put it this way. So in this kind of assignment, this is also professional assignment. And if you are, computing the fees and undercutting, then it is a professional misconduct. So I'm sure that so long as the fees are, contractual and reasonable fees, NCLT will definitely upheld that, the fees, on the fees part, change in RP is not advisable. Let's see now what would be the reaction of NCLT in future.
Okay, sir.
Sir, you have brought out one point. You have brought out one point, and I would just like to deliberate upon that point because that also issue came to me. You have said that as per regulation 4, the amount should be paid. There are two stages. One is amount realized, one is amount distributed. And then they say 6 months, and then beyond 1 year. So I would like all the panelists to give their views when this would trigger. So if I have realized an asset, let's say liquidation was done in January, I realized an asset, let's say in June, whether this 6 months would come from the date of liquidation or whether it will come from the date when I have realized.
The date of liquidation, in my opinion, because the wordings are very clear, you have to complete within 1 year. First 6 months, if you realize and distribute slab rate. Second 6 months, if you realize and distribute slab rate. If it is going beyond 1 year, there is a separate slab rate. Earlier, that was there for 2 years. When they reduced the liquidation period to less than 1 year, they same way they sized the table also to that extent.
Pandey sir, your views, sir.
I don't have view because you can go to any whatever orders are coming from IBBI on various liquidation matters where they have penalized the liquidator for charging higher fees. So it's clarified there what you have to charge. So I think you can just read one of the orders and it is clarified.
So we should calculate the way it suits us. Wait for the appropriate.
No. You just read IBBI penalizing of some disciplinary order. There they have given in detail. They have given tables how to calculate. I think that's the best way to avoid going on the wrong side of IBBI.
So what Suresh ji has said was normally the interpretation, and I was also of the same view. But my view changed when I read this one of the NCLT judgment, and logically also now I find it correct, because if you read the law, it says realization and distribution. It nowhere says liquidation commencement date. So Suresh ji, the liquidation commencement period is whatever date and regulation 44 1 year.
Correct.
Now it is going to happen. There could be an ED attachment. There could be a sales tax attachment. There could be n number of things where I may not be able to sell the assets because of that reason. So whenever the asset is sold, this should be interpreted in the manner when the triggering of realization happens. So if you realize it, that realization 6 months and beyond 12 months should be there. So that's what the NCLT has held. I would just share the judgment in the chat box. That is what the view of NCLT has come. So I was putting this query because normally everybody thinks like that. We have 1 year only, and beyond 1 year, we will always be in the last column of the slab. But now when we read the judgment, it says that triggering of an event of realization or of distribution. Because again, I have got one case where because of rainbow paper, there was a status quo granted. Therefore, I had realized the money, but I was not able to distribute because there was a Supreme Court status quo order. So because of no fault of mine, why should I get lesser fee as a liquidator?
Okay. Actually, for the same reason only, I also advise all the liquidators, whenever you get the by extension, when you want to apply in the liquidation matter, I always tell them first to look for any exclusion possibility, any legal hurdles or any COVID, anything. Please apply and get exclusion so that the exclusion will count even for your fee slab. First thing. Second, there are instances we have come across wherever the bankers have come and relinquished the asset very late, or some of the assets which because of the stay or anything which came very late. Those things, with the concurrence of SEC, it was minuted and the slab rates are applied from the date when the asset is available for sale in the hands of the liquidator. So why this table is, as of now, we are agreeing to apply is, on the day one, it is available in the hands of liquidator for disposal. So within 6 months, he has to dispose and take it. Certainly, if the assets are available in his hand very late, yes, these calculations should start from the revised new date only. That should be the ideal one.
My view is that 0 date remains the liquidation date because it has to, the calculation has to start from 0 date. The entire structure of this table is created for incentivizing early recovery and early distribution. So I think the liquidation date has to be considered as a 0 date, and then from that you. Yeah.
Okay. Right. Lipunji, just moving ahead from the fees thing. See, during the stakeholder consultation committee constitution, when we were discussing on the first point, so there were some other observations which we come across is, if a secured creditor is not relinquishing his security interest, he is not supposed to be part of the committee. So this is one of the regulation. Now the tricky question comes is, see, the secured creditor is have given a bigger sum of loan where the security interest is currently of a lower value. So there is an unsecured portion of his thing. So he submits one claim but he is not relinquishing his interest. So certainly I will be putting him in a portion for the balance in unsecured. Whether he will have the right to exercise his voting, participate in the stakeholder consultation committee to the extent of his unsecured portion of interest. So that's a tricky thing which was there. So you kindly let us know your views on that.
My view is that if there is a secured creditor and there is a security interest, we should go by regulation 37. Now that regulation 37 is assuming, let's say the claim amount is 100 rupees and he is able to fetch security in interest of, let's say, 60 rupees. So that's a tentative valuation. For that remaining 40, he would become the unsecured financial creditor. So that is my view if we go by the regulation 37, presuming he has taken out his security interest. So he will continue to be a financial creditor, but an unsecured one.
Yeah, I agree. Totally agree.
Yeah. And
So for remaining part.
so now on this reconstitution, again, many of the liquidators have a common question whether this reconstitution of the stakeholders consultation committee, whether it has to be filed as just as a report to the NCLT or you have to file it as an IA. This is a common question before the adjudication, before all the liquidators. And in case if you are filing by an IA, until the adjudicating authority takes on record this particular report, whether it will come into force or not. These two are some questions which very many liquidators are asking. So what is your views on this point?
Sir, my view is that the law says you have to reconstitute it and you should inform it to NCLT as a part of the direction of the NCLT president. But as such, the law does not say that you need to take accord or approval of NCLT. So basically, it will be just putting on record the reconstitution. So as such, I don't think any approval would be required. It will be more like a filing of a status report just to take on record.
When there is a change in the stakeholders, then you go to NCLT, where you say you take approval for change in the stakeholders list. But for reconstitution, you don't have to go to NCLT.
Not for reconstitution, but yes, for informing the reconstitution.
But if there is a change in the, because of deemed provisions of operational creditor of RP, suppose you change your stakeholders, then for those stakeholders which you are adding or rejecting, you have to go to NCLT, because the addition of stakeholders amounts to changing the stakeholders list. To that extent, you have to go to NCLT. So till they are admitted or approved by the Honorable NCLT, the new addition of deemed creditors will not be effective unless NCLT approves the change in stakeholders list. But for reconstitution, I don't think we have to go back to NCLT.
My view is practically one more step ahead, that now probably just like we have continuous COC, we will have to have continuous SCC, because if we do not have continuous SCC, then some of the decisions which we might take will tomorrow be objected. So therefore, my suggestion to everybody is that now you conduct SCC at least once a month, so that everybody is put to notice what you are doing, what is the information you are sharing. And even otherwise, now they have also put it in the auction that you will have to do an auction, and one, if it fails, then another auction, then if it fails, then another auction. So time limit is in a way now come. Previously, there was no such time limit, that first auction and second auction, there should be minimum this time limit. I think some 15 days time limit is there if the auction fails. So if it fails, again, in 15 days, you bring out another auction. If it fails, another auction. So you have to continuously do some work in the liquidation.
Okay.
On the same subject, I have a doubt on the same subject. Right now, one auction is going on for me in a power plant. The question now is, 12. Some people are asking for extension, and the total liquidation process time is 35 days. What will be my position? Do I have to cancel the auction and go for new auction, or can I extend it without affecting the 35 days clause?
No, in the auction clauses, if you see, they have written that the power is with the SCC to deviate for the timeline. So
Okay.
SCC can very well take a resolution and deviate from the timeline. There is no problem as such.
So I'll convene a meeting tomorrow before the new SCC is constituted, and with the old SCC, I will ask for extension time.
But sir, you have not reconstituted it now. 30 days timeline is expiring.
अभी 16 तारीख तक टाइम है ना, अभी तो 13th है.
But sir, now they say that you have to go by what was there in COC. So how much days notice will you give?
I'm a new liquidator. Some RP was removed and I was appointed.
But the amendment is that I think you should call reconstituted SCC, because otherwise again the court will say now you call reconstituted again.
I'll reconstitute on 16th, but my auction is going on right now and people are asking me extension. So whether I should give this 35 days law will apply to me, or can I do it without applying the 35 days law? Because
technically, if the auction is announced before 16 September, you can that auction will not be covered under this 35 days rule. Am I right, Nipunji? Because the auction is announced before the 16 September.
Absolutely right, sir. Absolutely right. If it is before 16 September, this will not apply.
so can I extend the auction date? I mean, extend it.
Sir, we don't know when did you do the auction. You have to give the date.
Okay, 28th September, I think my auction date.
Then this will apply, no sir.
This will apply. Mandatory.
Right.
Then it will apply.
So that means I cannot give extension. I have to cancel the thing and go for new auction.
See, anyway, 28th September, if you have announced, you have time up to 28th October. So 16th, anyway, you will reconstitute and you have time to extension now. You hold the FCC and they extend it.
Okay.
Correct.
35 days from 28th September works out to November. So you don't have a problem within that.
But in new guidelines, internal timelines also have become important.
Yeah,
12
you have
days,
to follow
14
it.
days.
Yes.
That 14 days, 7 days for visit. So those things are bothering me. Right today, that's my burning problem for me today.
Okay. Let us follow that up. Another technical, Nipunji. See now when you now you know in the SEC the present and voting concept has been removed. It is voting, which is at par with the COC. Now under the entire COC proceedings, the entire thing has been mutatis mutandis brought in here. So you know, with the presence of so many employee operational creditors and all, not even a single guy is absent for the meeting. I have to give them the e-voting option because COC regulation calls for absent member, you have to provide for the e-voting option. Erstwhile SEC decisions are across the table. It used to happen or sometime in that. Now post that you have to circulate the draft minutes, open an e-voting leg and follow up with those guys to vote, because anyway you have to keep it open for 24 hours, 48 hours. You know, SEC now takes minimum 7 to 8 days to conclude at par with the COC kind of thing. So what do you suggest? Because within 15 days gap, one action failed, second action notice you have to issue. So now you will initiate this process between this thing. By the time SEC has to agree upon some reduction and all those things has to happen. So don't you think this mutatis mutandis application of the CIRP regulation here without some exceptions like this e-voting option, absent member, it will seriously affect the performance of the liquidator in that case. So the removal of the word present and voting is a very affecting part in timely functioning of the liquidator.
I completely agree with you, and I think the logic of this, all creditors and representatives should again be clarified by IBBI, because if you read the discussion paper, it was very clear. They said that whoever is getting payment under 53, as per the liquidation value, they should come. So that was a bit logical, and we could have understood the voting also. But here, the baton of decision making is given to somebody who actually is not affected by the decisions.
Okay. Now, another out of the way question was from one of our fellow Insolvency professionals. Now, you know, in the RP fee structure, IBBI wanted to make it self-sufficient and all. So wherever you are incurring some CIRP costs, appointing professionals and all, the 1% fee is payable to the IBBI. So many norms have come. So equivalent norms have been updated for responsible and IP in the IP regulations also. The question before me was that will the professionals appointed in CIRP when their bills come in the liquidation, see, once the liquidation is ordered, the audit might have been appointed, they would be submitting it later. So now it has come under liquidation and you are clearing the bills under liquidation. So it will not go under the CERP cost. So whether that particular cost will be covered for the fees or not.
I agree, sir. I agree. It's an issue.
Now if the onus is made on IP. If we delay, we have to pay interest at our personal cost. And that fees cannot be included in liquidation cost because there is no clarification in the liquidation cost for addition of that in the same thing. That was one tricky question came to me, so I am just putting it to you. If you can share your views, it will be helpful. This is a regular scenario in many cases.
Sir, my only suggestion is that whatever you do, because if you do it with the backing of SCC, we are saved. So because if you see the auction also, they have given some hints that if SCC wants to relax, they can do it. Again, decision making also, they say go by whatever SCC does it. Otherwise, there is somebody who is going to monitor you. So my suggestion is, in such a precarious situation, we should always go to SCC and take a decision from them, rather than we applying our mind and taking a decision and then being hauled by the regulator that why did you do like this? It's better to take some backing from the SCC.
Yes. Okay. So next question relating to the 32 years sale as a going concern amendment has come. So now they made it as an exclusive option only at the first auction. Does this mean that in second auction onwards you should not try the sale as a going concern?
Sir, I think so. That is what their intention is. But again, I have got orders when even this 90 days was there. There have been many orders, in fact, that even after this period, NCLT can permit you to sell the corporate debtor as a going concern. In fact, in one of the matters, I have got an approval after 2 years of the liquidation commencement date. So NCLT can always permit, because if the concern is a going concern and somebody who wants to buy it as a going concern, then definitely NCLT would permit it. Yes, but the regulation as of now are giving a very tight compartment for compromise and arrangement and sale of going concern. So I think courts will always be relaxed as far as this is concerned.
Okay. So next, the typical question, because you have raised on the compromise, the duty cast on the liquidator is to file the petition within 30 days for the compromise or going concern. See, the liquidator will file provided there is a proposal received from the related party, some concerned party. If no proposal comes, see, in the COC, they would have all said, let us try, let us try, let us try. They will keep on trying. But within the resolutions are passed in COC to explore that thing. Now, within the first 30 days, if nothing comes, what is the fate of the liquidator? Can he go and say, file a report in the court that it has been explored and nothing has come? Is there a compulsory that he has to go and file the thing? Or he can say that if nothing has come, so we are not applying this one.
So I will just open the regulation. Let us see what it reads. Proviso says further that where the recommendation to explore proposal of compromise or arrangement has been made by the committee under regulation 39BA, the liquidator shall file the proposal within 30 days of the order of liquidation. So in my view, 39BA resolution, wherein they say that we would explore the scheme of compromise and arrangement, if that resolution is passed, then this proposal of scheme of compromise and arrangement should be filed within 30 days. Otherwise, we have that upper cap of 90 days always there.
Okay. So it means under regulation 39A, there should have been a compromise proposal received from the concerned party. Then resolution should be passed to explore it. Am I right?
Sir, 39BA is a resolution which has to be passed when they are planning to take the company into liquidation.
Right.
Now, 39A, B, C, BA, they all are there when they are thinking that we want to liquidate the company. So the amendment in CIRP regulation says that suppose you have taken a resolution for liquidation and you have also passed a resolution for scheme of compromise and arrangement, when the application is pending for liquidation before NCLT, COC would meet continuously and explore the possibility of compromise and arrangement. So when they're exploring this scheme of compromise and arrangement, once the liquidation is commenced, within 30 days, they will have to bring about a proposal to the court. So I think only in case of 39BA, we have 30 days. Otherwise, we have 90 days.
90 days. Okay. So another clarification, you being the expert person on this judgments, now the sale as a going concern has become exclusive in the first thing. Given the latest judgment of NCLT in the sale as a going concern, where the liability also dwells on the buyer, what is your suggestion or guidance to the liquidator to safely play it? Because if the liability is supposed to go to the buyer, then no buyer will come and look for the sale as a going concern. How we have to carry out this particular process for a safe buyout by any buyer? So what's your suggestion for that?
So I think I will share my paper also, which I have written and which has been published by IBBI. So my view is that suppose you want to get some benefits, some concessions, some reliefs. As far as the sale as a going concern is concerned, what I suggest is always there should be two applications filed, one by the liquidator and one by the purchaser before NCLT. That is the safest route, because some NCLTs have taken the view that if the assets are sold to the liquidator, sold by the liquidator, he becomes ex officio. Some views are that if the liquidator is still there and concessions are to be given, liquidator should file and purchaser should second it. So my safest view is that both of them file together, asking for reliefs and concession. And in that case, clearly say that because of the judgment of Ghanshyam Mishra, all the liabilities which were there on the company should be zeroed down. According to me, the liability which can come to the purchaser at the best could be some critical liability. Let's say there is a lease lent by government. Now that lease dues will have to be paid by the purchaser, because that is something which is as is where is basis. So that is something which has to be done. Secondly, I've seen cases where the non-compliance of financials, balance sheets and all is there. Now in that particular case, if you do not ask for a relief with regard to ROC fee and late fee, then again it will be cribbling on the purchaser. So all these things where general concession and waivers can be asked, should be asked. However, there are some litigative issues like carry forward of losses. There is no clear-cut judgment wherein it is permitted. Some NCLTs have permitted, some NCLTs have not permitted. So bunch of release and concession. In fact, recently I saw one of the order of, I think, NCLT Chennai, wherein they have also directed that the account which is shown in CIBIL, the score is gone down because it was a write-off account. That also should be upgraded because of this sale. So such type of orders obviously will have to be taken from the court, that some reliefs and concessions are inevitable for the buyer. Otherwise, the purpose of buying as a going concern would go away. Everybody would then buy only the assets, because logic of taking liability only comes when it is either critical for the conduct of the company or something like this, that let's say there are carry forward of losses or there is GST input tax credit in the accounts. All these issues would come.
In this particular sale as a going concern, so we had come across some of the auction documents wherein the liquidator specifies that the company sale as a going concern is for all assets and the liabilities will be settled by the liquidator out of the realization under section 53. So your balance sheet is recast excluding the liabilities portion, which will be settled through under the section 53. Will that be valid? If they give a recasted balance sheet, like how we approve the resolution plan, they make the recasted balance sheet. Same way, if they do it for sale as a going concern during liquidation, will it be valid? Such a recasted balance sheet can be part of the asset sale, means the e-auction memorandum, the sale memorandum, sale document, process document.
In fact, I have got this query from number of liquidators, because this stop-worth order of NCLT Mumbai, therein the court has said that whatever changes have been requested by the purchaser would be given effected by the liquidator and then handed over to the purchaser. So that is again a very ambiguous proposition, because if you give effect to the balance sheet and P&L, we don't know what will happen in the tax laws. Probably accounting treatment may be one thing, but the person who is buying will again have to suffer something from the tax department. So that is again my suggestion to everybody is just like we have in scheme of merger and acquisition, put one specific annexure that this would be the accounting treatment. I always request everybody to bring that accounting treatment on record while making an application so that everything is clarified by the court itself.
Okay, so the another question now on the treatment of avoidance of transaction and all those things, where many of our fellow liquidators are stuck with the pending closure of the thing. They are trying with NRRA route under 47A, but and they are many of them are unsuccessful. They are not getting a buyer for that. So one side they are not getting a buyer for NRRA of that asset. Another side, none of the stakeholder, none of the creditors are willing to take the case on assignment to them against settlement of their liability. Now, as both the things are hanging, what will be the fate of the liquidator? How can he exit from it? Although the option is given to SEC to discuss and all those things, if SEC doesn't come to a conclusion on it, liquidator sits with it, and when the liquidator goes to adjudicating authority, there they fire. What are you doing? You don't. Why are you not completing?
Sir, I have faced such a situation, and what I have done is while filing an application for closure, we have made those members, because now SEC is bigger, but at that point of time, we have made all the financial creditors as a party and requested the court to issue notice to them, so that when the notice is issued, it will be clarified by the creditors themselves before the court how they want to run these applications. If suppose they want to abandon the application, again it is their call. As a liquidator, we can't do much about it.
Another thing, coming to regulation 45A, now preservation of records have become one more thing at par with CARP they brought in here. Now, when the liquidation in this record preservation issue comes up, say liquidator at the end of it, he gets discharged. Upon dissolution, he gets discharged completely and goes off. But because of the taxation or any other matter, the records have to be preserved for 10 years and or 8 years under respective statutes. Now, in case if a notice comes from income tax department or from any other department after the dissolution is ordered and the liquidator is discharged, is the liquidator bound to reply on his personal account, because he is no longer the representative of the CD? On his personal account, he is bound to reply or not? So that's the first question. And obviously the records, maybe he might have preserved it with the other party and all. What is the authority he has to retrieve and submit on behalf of the CD and defend anything in that matter? See, if IBBI as far as adjudicating authority as far as a different matter, even another statutory authority, other parties ask for what is the stand of the liquidator.
So, sir, I think normally I have taken such orders where in dissolution also, if suppose some money is about to come, let's say income tax refund or something, we request the court that if this particular amount comes, we will open the bank account, get the amount there, distribute it, and again file the distribution with the court. So court is giving such orders that they are dissolving it with a direction that if something comes, they would distribute it. As far as compliance with any law is concerned, definitely we are duty bound to comply with any authority's notice. But yes, if such things come, please put a separate litigation fund, and that I always suggest to all the liquidators, whenever we are closing down, please put some amount aside so that if tomorrow some contingency or litigation comes, we can at least utilize that amount. Otherwise, it would be personally, we would get some liability. Secondly, I have also seen some cases where, let's say forensic, we have come, it has come in our favor, and there is order against the promoters. Now promoters go to NCLT in appeal, and they, in the meantime, the appeal is disposed. SEC thinks that we should close down the company or dissolve the company. So then who would fight the litigation with NCLT, or tomorrow maybe Supreme Court? So you will have to set aside some money for the litigation fund. And therefore, I always say that some amount of money has to be separately kept, maybe for 6 months or 1 year, and then that amount could be distributed if there is no litigation, and close the account.
That fund, you mean to say that you will open some third party, some account you will keep it, because if the liquidator takes it to his personal account, some observations will come against him.
No,
So
I have got.
at the same time, you cannot have company account open, because company account open is there, dissolution cannot come. So
No, sir. We have got such orders where this litigation fund could be kept in the liquidation account only. So that liquidation account would be live for 6 months or 12 months, whatever you pray for. And
Okay.
that account would be closed only after the expiry of that period.
So until that time, you are also not discharged as a liquidator.
You continue to be liquidator for the limited purpose of that bank account and distribution of proceeds. You can refer, I will share the judgment. The citation is of Vinod Agarwal, liquidator of JR Diamonds. You can read that judgment. That in that judgment, I have specifically got this order done.
That was Vinod Agarwal, this is GR.
JR Diamonds. JR Diamonds. Sir, Nipun sir, your audio is off.
Sorry.
JR Diamonds.
JR Diamonds Private Limited. It's a NCLT
GR
Ahmedabad.
or JR?
J for Junagadh.
Thank you very much. Thank you.
R for Rajasthan.
Always after completion of liquidation, some amount can be kept in the same account towards
Okay.
the litigation excess and all that. That's what you are saying, no? Sunilji,
Yeah, yes, sir. Can you repeat the
Mr.
question?
Mahalingam, that's what he's saying, no?
Your question is not clear, sir. Can you repeat?
No, even after completion of liquidation, if some litigations are continuing and we need some funds towards that, we can keep aside some amount in the same liquidation account of the corporate debtor, and he will continue for the limited purpose of these matters, he will continue as the liquidator. And once the matter settled, whatever amount is left, that can be distributed among the stakeholders. That's what he was saying, no?
Correct. That's what.
Okay. In fact, I am also having a problem like this.
Yeah, you can go through that particular court order which Nipun ji has given. And Nipun
Yeah,
ji.
Vinod Agarwal versus JR.
Yes.
Oh, nice.
Okay.
Thank you, sir. Thank you.
Nipun ji, there were some other smaller minor questions. See, Regulation 12A newly now process email ID has been introduced. In case if the previous IRP or RP has not created such mail ID and they have used only their routine personal mail IDs. Now, whether the liquidator who is currently doing it, whether he is duty bound to create a new email ID for this particular process, or saying that IRP has not created, so I am not bound under this particular regulation. What should be the safer legal position for the liquidator?
The process email ID should be created immediately because now the regulation are into force. Tomorrow we might not be continue as a liquidator, we may be replaced. So therefore, there could be a contingency when we will have to hand over it to somebody else. As far as the old liquidator or RP is concerned, we should take the complete data dump of their email, because if it's a personal email ID, he would have to give the data dump only. That is the only way out, which I think is possible. And secondly, I also suggested on the last occasion that process email ID should be a business email ID rather than a personal email ID, because then our personal date of birth and banking details or maybe phone number, all those things are not attached to it.
So, I'm just coming to our old discussion on the liquidator fee related matters. See, if you had referred Regulation 4, now the amendment 1A, where no fee is fixed under sub-regulation 1, the consultation committee may fix the fee in its first meeting. So that means if fee is fixed, the consultation committee cannot refix the fee. Is that the position?
Sir, my view is again that fee of the liquidator, because it is a given item, probably they would come with this fee issue. And suppose they come up with this issue and we do not deliberate, or we say, no, everything is fixed now, nothing doing. Probably an adverse view might be taken by adjudicating authority, because the way we know how the courts look at us, how the regulator looks at us, we cannot just shrug somebody to side and say, no, we will do like this. So my view is, if suppose there is some negotiation, you should be open to it. And if there is a substantial difference in what we are expecting, then let us gracefully step down. That's my personal view. Sunit ji, I think you are on mute.
Sir, one question is about the puff transaction. As you said, the stakeholder committee will decide upon if some of the amount is recovered after the puff transaction or puff application is disposed of. So, sir, will that be possible, or will that be able to sustain that? Because in any case, whatever amount that will be, if at all recovered from the puff transaction, say after a year or two, will that not be compulsorily going as per the waterfall mechanism of Section 53? So is there any scope that the SCC may also discuss on this? I think so. It's a deemed provision that whatever will be recovered. Yes, during CRP process, resolution applicant do negotiate the things that if the recovery is done, 50% I will retain and 50% will go to the creditors. But in this case, will there be any scope of this discussion also for this puff transaction application already filed?
My personal view is that suppose there is a cost of 10 rupees attached to continuing puff transaction, and suppose tomorrow we get 100 rupees. So obviously that 10 rupees, whoever is funded will have to get it back. So suppose two banks are there, one bank is funding you for the litigation and one is not. So probably whatever they are funding for the litigation, they will get in priority.
Yeah, that is okay, sir.
As far as the balance money is concerned, it will have to go by the waterfall only, because the liquidation regulations cannot override the section, because they are subordinate to the section. So anytime regulation cannot override the law, and therefore as far as law is concerned, waterfall will always be there.
So then why they have come up with such a amendment in the regulations also? So it's a deemed provision, I think.
No, because I think that the problem is because of the DHFL judgment, two things have popped up. DHFL judgment, NCLT has given a ruling that whenever resolution plan is to be passed, you have to clearly mention what is the amount in which you are selling the puff transaction application and what that amount would be coming, whether it will go to X person, Y person, or to everybody. Because what had happened in that particular case, many of the fixed deposit holders or the financial creditor class are getting zero amount, and bankers, secured creditors, they are getting full money. So the issue was that some people who were there in COC, still they are not getting the payment. And puff transaction of around 35,000 crores something has been sold at a nominal value of rupee 1. So that particular issue was remanded back to COC for consideration and saying that you should negotiate it at a reasonable price. So my view is, suppose today, even under liquidation, this puff transaction application is sold, that money will always be distributed as per Section 53.
Yes, sir. So any more questions? Because panelists have time only till 6 p.m. So we need to finish it off by that time. Yes, sir.
One more question which our fellow liquidators have asked. See, if now the provision gives a option of puff transaction, how it will be dealt post liquidation closure and dissolution. Let's assume it is assigned to somebody and money is getting realized. The money realized is also getting distributed under Section 53 waterfall mechanism. Whether a liquidator is eligible for realization and distributor fee in that transaction post closure of the liquidation and dissolution is another question raised.
Obviously, sir, we will not do work for free.
Correct, but see, you may not be doing it, somebody else will be doing it. Whether he is eligible for the fee is the question which came up.
So I think, sir, again, that will go by the reasonable fee, whatever is decided.
Slab rate, which is reasonable. So there is nothing wrong in applying the fees if it is so.
Correct.
We will, Sunit, we can take up if any other questions.
Yes, if any other questions,
people can unmute and ask.
Nipun sir, Dhaval here.
Yes, Dhavalji, please.
Sir, while forming the new SCC, all those claims which has been received during CIRP, but not received in liquidation period is to be included?
Yes.
New SCC?
Yes.
In ongoing liquidation cases also?
Now, here there is a tricky situation. If it is an ongoing thing, we will have to see how much time has lapsed. Because if too much time has not left, I think we should consider it. Even because of rainbow paper, this amendment has come, that you go by the books of accounts and the claims which are there. Secondly, even there was an amendment in the liquidation regulation before this amendment, that if the claim is there, a person can update his claim. So as such, if somebody has filed a claim, it is always there. I have been advising people that please continue to take those claims, because once he has filed, once you have collated and verified, that claim exists in your claim list. So my view is, if there was a claim, any which ways you have to carry it forward. If suppose you have not done it, then do it now.
Okay.
Do it now, but take it to the court so that court is aware, because modification of list of stakeholder will also happen. And
Yes.
if there is a new stakeholder coming, you will have to inform the court, because of rainbow paper judgment and this amendment, I am moving this application. Because once you go before the court, court will never say no to you.
Exactly. Okay. Thank you.
Mr. Nipun, one question now. Sorry, I'll
Yes,
get back. I'll get back. Sorry.
Sir, also about as one of the amendment, like all the creditors will be the part of the SCC committee, as you said, sir. So last time when we had a session about CRP, so all the creditors will have to be intimated about the CRP process, right? So similarly will be the case in this also. I think so. There's no specific mention about this intimating to all the creditors to be the part of SCC. But then how all the creditors will be intimated or will be able to form part of this SCC without having the intimation? Even during CRP, they were not having the intimation. Now, how they will be having the intimation of the company going into the liquidation?
So I think, sir, you have raised an important point, because regulation 12 talks about public announcement as far as liquidator is concerned. Now in public announcement, only this clause C has been added, which says that it will be presumed that whatever claim was filed in CIRP will continue to be there in liquidation. So as today, please do not give new hints to IBBI. Again, your cost will increase. Because if you say, inform every creditor, you are in dock. Because suppose there are 1 lakh creditors, you can just assume informing them will cost you good amount. So my suggestion is, as of now, it is not there in regulation. So there is no requirement to as such inform each and every creditor. But yes, public announcement should be done, and whatever claims have come in CIRP should be verified during liquidation.
No more questions now. I think so. Rishabh bhai, you can.
So I would like to express my gratitude to all the esteemed delegates of the webinar for their presence and contribution to make this webinar a grand success. I extend my gratitude to our eminent speakers and panelists, Mr. Nipun Singhvi sir, Mr. Sanjeev Pandey and Mr. Suresh Kumar Mahalingam. A special thanks to Mr. Kranthi Kumar, President of HIPA, Mr. Kalpana, Secretary HIPA, and Mr. Sunit Shah, Managing Partner Director, SKYZ Limited, Chartered Accountant, and Mr. Hemanshu Kapadia, sir. Thank you so much.
Thank you, everyone.
Thank you, everyone.
Thank you, everyone. Thank you.
Thank you very much.